Hello, loved ones. We are very excited to be able to deliver you a bonus Q&A. And the reason for this is we know on the last one we didn't quite get through as many questions as we wanted to, but nonetheless what did come through was meant to. But at the same time, it did leave us with several unanswered questions. So here we are. I got Darren all hooked up to a mic. We're going to blast through a whole bunch of these questions and we're going to get to the bottom of this. So here we go. Question number 1. Darren, are you trying to make the judge the trustee?
I'm going to say ultimately no. However, it has a trustee flavor to it. The judge will take possession, or the court will take possession of particulars of property for particular reasons for just long enough to effectually do what they were meant to do. So consider him, at the very best case scenario, a quasi-trustee. So they're kind of not really a trustee. The resulting trustee, that's the one we're interested in. That's the one that happens after the judge sees our trust expressions and all the evidences that we're bringing forward for him to make a consideration on. Therefore, no. But directly, we're not making them trustees, no.
Okay, so the next question that went off of that is, so who's accessing your birth estate trust for which you are the beneficiary?
You are accessing your birth estate beneficiary trust. You are the only one entitled to do it. All these other quasi-trustees running around out there, they claim to be acting on your best interest because you engaged them in contract to go do it for you. So they're not really the real deal, and neither are you.
Okay, because we have some different people in this common law equity arena who have varying opinions. One of them is a woman who is under the understanding that we are about making the judge the trustee. So she's challenging you by asking you what happens if that trust is not accessible because the governments have been cut off.
Well, those governments were meant to get cut off because they're all temporary in nature and public in character. When a private citizen, a private individual comes forward doing the shit we're talking about doing, we are the proximate reason why those governments are falling apart. It's because of us. So clearly, yeah, we're doing the right thing here. Those governments that will no longer be there tomorrow, it's because we've stepped forward to take over. There can't be two governments, and it's going to be us. Because we're not acting in person.
So this same person is under the assumption that the system is now using family services to access the trusts. They are wondering...
Well, okay, hang on, before you even continue with that. Family services can only access a trust by the judge's seal. The judge making a determination in a case. Which can be done. I mean, the Attorney General, on behalf of the Minister of Health, could bring a case where they can have public things like mandates put forward. Sure. But the point is, family health services or family services, whatever legal title they give to it, it doesn't matter because it's still a public office. It is no business of ours. It's in the public arena. We literally don't give regard to that any further. We stay on this side of the fence exercising all of our private stuff. Private entities, private entitlements, private enjoyment of, the benefit of your knowledge.
Okay, so the question is more around if you're trying to take over the government or you're trying to usurp the control system and force it to function properly, that system's already been dismantled. So they're confused as far as what your solution is.
That system is being dismantled because of what we're doing. And because of people like us expressing trusts. And the governments having known for numbers of years that we were going to come forward to take over one day. Again, they would not have sent judges from the United States to Canada to train Canadian judges on certain things regarding equity and trust stuff. I've seen firsthand correspondences between the IRS and CRA, and this is going back 6-7 plus years. They're opening the doors for all the beneficiaries to flood the scene all of a sudden, from all these crazy trusts being expressed and all the proper interests being conveyed and transferred and moved around. That whole economic tidal wave is a result of what the hell we're doing. This is the national debt of a country being extinguished. Is that a big deal or not? Oh my God, of course it's a big deal. There's no greater financial event to happen. These corporate events, these corporate entities have been operating on the debt side of the ledger, and then they get us to assume the liability of that debt. We're the ones that keep the system going. Those governments are meant to fall the moment we have enough wisdom to stand in our own right. Now again, the governments are not the judges. The governments are not the judiciary. The governments change every 4 years. Judges don't. They're lifetime appointments. Who's of a higher regard, the judiciary or the governments? The governments, think of them as the janitors of the system, while the man or woman is absent the whole game. Someone has to manage the fort.
More of the questions are around if we are about dismantling the government, how do we replace it? What does that look like?
Yeah, no, we're not dismantling anything. We're actually putting the proper key into the proper lock, unlocking the whole system, and the door opens, then we walk through it. This was the proper way for the system to operate. We're the ones that create the fraud or the disturbance of the peace by acting in person 24/7, which gives them cause to come after us with all these acts and statutes, because we're the ones who actually usurped the government by acting in person. We're actually just fixing a mistake we made.
So in other words, we're not going to be removing the current government until there's a new government in place.
Again, imagine the government is an engine. All we're doing is switching gears.
Upgrading it.
Upgrading. We went from neutral to drive. Or, okay, literally, we went from reverse. Once we transfer our securities properly, that is putting it into neutral. The engine recognizes, oh, we got some options now all of a sudden. So depending on the next move of the player or the stick, however that stick moves now is going to determine whether this vehicle moves forwards or backwards. It was always moving backwards. It's about to move forwards for the first time. The engine actually doesn't change.
So you're not building a whole new system.
We're not building a new engine. We're just using it properly.
Okay, so moving on to the next question. Do we list the director and administrator? And can they also be the trustee?
Directors, administrators, executors, all these positions are the trusteeship position. What was the rest of that question?
And can they also be the trustee?
So yeah, of course, that is all a trustee position. So whoever's in that position, you're a trustee.
Does one need to file the case of the adverse title at the public courthouse, or can it be brought into a current case in the legal system?
Yeah, bring it in either respect. You can mail it, show up with it, and I've when I was being arrested one time and I knew I was being arrested, I made sure I had my particulars of live birth on me. So when they arrested me, that was my form of ID. It got confiscated when I walked into jail, and I made 13 requests to the superintendent of the prison facility to be put into possession of that particular instrument because I needed it for court purposes. And they dodged the ball, said they didn't have it, they didn't know what I was talking about, this, that, and the other. Played the game. The day I got released and I'm being ushered out of the prison, the guard hands me the piece of paper back as I'm going back out the door. But anyway, we have a number of methods to get rid of that thing. You can do it vocally, standing in court. You could read it from a script if you wanted to. Again, all you have to do is know the registration numbers. You'd have to know the particular numbers and dates of issue and things like this on that particular instrument so that you can negotiate it properly. And back to that other question there from a moment ago, the administrator part. Again, an administrator, he's going to be sort of an overseer to make sure that certain things are being respected or done with respect to all the processes that we're talking about. This is where the Attorney General in a certain capacity will actually start to administer the estates for us, which is stuff I mentioned a long time ago.
Okay, we have another question from a loved one. If one does a private process for a notice of interest, So for instance, using registered mail. And trespass does occur. Does one file that into a civil court with a civil claim? Because this gentleman did that, but I don't know how to file it into a private court.
Yeah, okay, first and foremost, make sure your trust gets recognized and that it's established and that it's agreed to and the judge sees it and da 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 da. Get all that done first. If there's harm or loss experienced in that stretch of time between when the trust is brought forward versus when it is registered or recorded, there is a period of time there where, although the interests are remaining perfected, there's a liability issue now. So if you experienced harm as a result of something, if that harm could be reduced to a writing where damages or relief could be granted, then yeah, absolutely, you put that into an affidavit and say, Your Honor, as a result of my trust not being recognized, I'm now experiencing hardship, or my life's in danger, or da 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 da. Again, you're trying to create an emergency here. So that would be a perfect segue to bring your evidence to a judge.
Next question, when we go to court, who is going there? The person, the man, or both?
Depending on what your intent is today, absolutely the man is going and the person's going.
And what should we not do?
I would not go to court in the first place. I would settle privately with the Attorney General. Send him a written admission and some statements and some evidences and we'll see what happens there. But you got to know what to write, though.
Now, is a probate or bankruptcy judge required to access the account?
Yeah, anyone can access the account that you grant power to. Your little sister could. I mean, if you could really convince a judge that your dog had the ability to access your PIN number and go online, and he would grant it. Point is, you can grant that power to anybody. Dolphins are considered persons.
You can grant anyone to access your personal estate?
Absolutely. You're the grantor. You can settle it. You can name a beneficiary. In the future, something that doesn't even exist today, you can name as a beneficiary.
Anything with a heartbeat.
Yeah. I'm even going to suggest for the time being, you could even name a corporation, the Humane Society, as a beneficiary to receive X amount of my estate in remainder, or at the end of 5 years, or however you want to style the trust. Humane Society will have your funds as per your will. But again, you don't have to do this when you die. We can be doing this right now.
We have a loved one who is turning in their child's birth certificate with an adverse claim. The question she has, and she's 11 years old, does she sign it herself?
I would.
At what age should
we're
the
here
parents
to
sign it
we're here to push the envelope and go where no one's gone before.
So should the parents put the child's fingerprint?
Yeah, put caregiver, caregiver.
Or should they put the child's?
Yeah, do everything for the child. Yeah, do everything for the child, and then underwrite it with mom and dad's.
So the child's not going to have a signature, of course, or the baby, but they can definitely put their red fingerprint.
A mark constitutes any style of imprint on paper.
Okay.
You could literally put an X. And if mom and dad say, yeah, that was little Susie's name because she was too scared to put Susie, she put X.
What if we're talking a baby here?
Well, yeah, but then put the baby's fingerprints or the whole handprint on it.
But if they have the ability to hold a pen and put a little signature, get them to do that.
Absolutely.
Okay. Perfect. Shall we be filling out the tax forms to indicate disposition when we surrender? So the whole federal tax side of this. Okay, we're instantly talking about trustee work here, remember, folks. But let's just go there anyway. Yeah, you can get involved in the tax forms. There's all types of clearance certificates where once you establish a trust, now again, there's going to be there's going to be about 20 different trust options when you start getting at the federal level. There's resident deemed trust, there's personal trust, there's trust for this and trust for that, and non-income bearing interest, there's all kinds of trusts. So point being, you're going to have to identify which particular trust it is that you're dealing with. For Canada here, I believe personal trust is code 300, something to this effect. Anyway, once you start this, you're making declarations, you are providing social insurance numbers or social security numbers, and you're doing a whole bunch of stuff getting that process started. Now,
it does get to be a little bit over your head pretty quick. And you'll find yourself in a situation where, shit, I don't know what to put on this line. And there's no real 1-800 number where you can call and say, hey, what do I put on form 1049? What do I put on line 13B here? Like that, no. They don't really do that in our favor because, again, we're deemed to be lunatics already. So this is where I'm suggesting, if we stop trying to do the trustee work, let them do it. It's in the proper hands. The documents are safe. All the proper parties are involved. It's all under the discretion of a court, probably sitting on the equity side if you've done it right. Administrators, receivers are being appointed. There's a whole realm starting to engage the moment we do this properly, and there's that entire mechanism is already in place. So, yeah, go ahead and if you want to continue being familiar with all that federal trustee tax side, go ahead. Because, again, knowledge is never going to hurt you. But just keep in mind here that that's ultimately not what we need to be concerned about.
Now, what wording is needed for the declaration and the proclamation to smash the two interests together, as you often say?
Okay. We all have the ability or right, legally created in character, to go and act for that name, correct? You can act for your name, you can act for your name, and I can act for mine. And I can't really act for your name unless I had permission from you somehow. Okay, so we all have our own name. That is a character. That is one entity or one capacity. It's a fiction by design, as we all know. It's not really real, right? We all know it's all theater. But anyway, that entity is one party. And then you could have another party, which is the man living his normal life, not acting in character. Okay, well, what's that man called? Well, that's just a man without the legal title. So therefore, that would be a party B, would it not? So if we have two parties of interest in the same individual / man or woman, we all have the ability right now to express an agreement with yourself. Think about that. You can come as party B in an instrument as the all caps. Plus, you can come as party A as the man or woman styled normally in your living, breathing spiritual capacity. That's the equity side. That's the dual capacity. Your Honor, this written evidence is a record of, or establishes that, and declares such to be the truth, and proclaims further to say that on such and such a date, this transfer relating to this title was transferred with the intent to purpose a trust or fund a something, or, you can just go on and on and on from there.
Okay, so hang tight on this one. We have two security agreements that have been named differently for each party, so I'm just going to separate them here. My original security agreement cited Manitoba statutes and named Party B as Treasury, care of Registrar General of Manitoba, secured party / successor in interest / transferee. Does this second security agreement, that is to accompany the individual letters to appoint and discharge, name Party B as Her Majesty the Queen, in right of the Province of Manitoba, care of the Attorney General of Manitoba, as the secured party, successor in interest / transferee, or do I keep this second security agreement worded the same as the original security agreement?
Primarily, as soon as you start engaging the certificate, that person acts as an agent itself in the entire game. So we identify the principal as the crown, as we know. So really, the person is going to just remain to be treasury. That person is the public and the private interest. That certificate is a trustee. That certificate is a beneficiary. It all depends on how we use it.
Alienation means to renounce prior alliance, becoming foreign to the Creator. Is this not a form of quitclaim? If so, does this not mean that naturalized citizens are not entitled to equity?
Yeah, naturalized citizens are still, again, this is part of that personage verbiage that's here to confuse us. You're still in the person world. Whether they want to stick natural or what was that? Naturalized. That's all the same thing. So.
And is it not a form of quitclaim?
Well, yeah, if you spin the quitclaim deed properly, where you're suggesting I quit claiming to be primarily liable for the creation of another party.
So you're agreeing to being foreign to the person or to the monster, not to creator.
By saying by exercising my alien ability to this person, you're literally detaching.
How do we come into equity with clean hands if the definition includes the removal of the legal person and we haven't done that yet?
Okay, so say that one again.
How do we come into equity with clean hands if the definition includes the removal of the legal person and we haven't done that yet?
Okay, I'm going to suggest we get into equity with clean hands by disposing of our filth, giving it to the undertaker, and let them having a ceremony that takes care of all of that. Once that's done, now we can go ahead and do everything it is that we wanted to do. Okay, so back up. How do we put security interests into the hands of the undertaker? Well, a private individual, a private citizen is probably going to privately contract with the Attorney General, who's probably going to bring a quiet claim against the Crown or Her Majesty the Queen and right of the province or territory that she happened to be in. And then the Attorney General will stand in action for you.
Should a husband and wife bring their petition, their birth certificate, and their affidavit together as one package to the same judge?
Yeah, but before we send it to the judge, we are probably going to direct it to the Attorney General's office and settle this privately.
If I don't have silver or gold to attach to a document or item for consideration, would it be reasonable to attach soil, hair, or a leaf, a piece of my clothing, as an alternative?
Sure.
The court process.
Valuable consideration, that can just be defined. Love and affection is one, which is not really used by people acting in person anymore because a person is not capable of love and affection, which is why they took it away from us in like the late 40s or early 50s or something like that. So point being, if love and affection can be expressed through a locket of hair, a rock, whatever, it's all valuable because it all came from the earth. It's not of the fictitious world primarily. That's the difference.
Some loved ones who would like to hear a little bit of the evidence of successes that we've had in equity, whether that was good or poor. It seems that he mentioned that there's people at all different various stages of pursuing this. Who has had success and to what degree, he's wanting to know.
Well, other than the personal jail experiences that Dean and I have both experienced where we're just released, or when you're capable of having over 100 charges against you dropped by the Crown, like that's pretty good. Writing yourself out of solitary confinement and being sitting in a restaurant and drinking a beer 4 hours later, well, that's pretty impressive. When I came to understand and started dropping some equities respecting a case where my person was involved, where I was acting incorrectly for it, and that person happened to not want to pull over when the alleged authorities were pursuing the person. So that led to a federal charge where I was, still acting in the wrong capacity. Well, that whole charge was withdrawn by the Crown based on a 15-minute phone conversation I had with my brother the night before. I was mysteriously dragged into court the next morning, and that was all dealt with. Dean has got first-hand information and knowledge, and because he was a part of this, where a farmer in Saskatchewan was being foreclosed on in a mortgage foreclosure, and Dean got the gentleman his principal amount of the mortgage back, which happened to be about $1.5 million. The man was still forced to leave the property, though, because Dean dropped the ball when it came to negotiating the settlement terms. Dean did not demand and require the possessory interest of the property, as in staying on the property. So the gentleman was still forced to leave, which was kind of funny. So here's a check in a foreclosure for the principal amount that we're trying to collect, but here, we're going to give it to you. The fact that we are having successes in court where the tables are significantly turning because the judges are no longer denying the trusts brought before the court. The judge is no longer denying why an appointment of trustees is possible. The judges are not denying why the heir of a particular estate is in court. The judges are not denying any of our equitable pleadings. They're not scrubbing or dismissing any, they're not overruling any of the things that we're saying when it's coming to equity nowadays. We've got a couple of instances from loved ones who've just went through court, and you can tell by the demeanor of what's going on, wow, has the dynamic of the court ever changed? This is not how it used to be. And again, it's only because we're coming in peace. And the clean hands doctrine, that is so important. That determines whether you are to be seen as an enemy combatant or a friend. How is the court going to receive you when it's presumed that you're a joint tenant in common with Her Majesty the Queen in right of the province in which you are residing? That's an act of war. It's an act of war because we neglected to express a proper interest in our certain entitlement, and thereby neglect, we forfeit the right to. Boom, it's not even yours to exercise anymore. It's gone. It's somewhere else. Someone else has it. So now it's a matter of fixing the mistake, error, accident, fraud. Fraud is a big one. And I'm not suggesting the Crown committed the fraud. I'm suggesting you admit to committing the fraud. And that's how it's equitable that you fix the mistake, Your Honor. Equity automatically takes jurisdiction when you are talking about accidents, mistakes, and frauds. Throw errors in there. That's outside of the legal world.
It's interesting to say that fraud is outside of the legal world.
Because the legal world is a construct of fraud. So fraud cannot relieve fraud. It can't. It's impossible.
Okay, so there's a few that we can talk about. Next question is, when Darren referenced the et al. On his petition, is that how a family goes through, or is it done individually?
Yeah, you know what I mean. Unless if you've got 19 members in your family and you are tired of repeating all their names, again, typically in the captions in the clauses of the paperwork that we're styling, in the very beginnings of it, you would just refer to all the individuals by name, and if you want to bust that up into Christian names or / person names, and that they're acting in their dual capacity or they're present in their dual capacity with the intent to release one, however you want to style this. But really, yeah, identify all the parties once, and then from there on in, you just identify that group of 19 as Party A.
So do we need different trusts to deal with different things, like with the banks, healthcare system, driving, etc.?
Depends on what you're doing. If you want to deal with those entities one-off, yeah, go grab a birth certificate and express the trust for each and every one of them. Or go grab one certificate and send it to the boss of all of those public entities and let him deal with it.
So when we change hats from settlor to beneficiary, for a moment, do we need to express those terms in the trust?
Yeah, I mean, just define them as my obligations acting in the capacity of such and such for the purposes of such and such on such and such date at such and such time have come to an end.
Do we have a new paper trail of exchanging trusts between trustee to settlor back to new trustee?
Do we have a paper trail? Yeah. All of the evidences that we're talking about with the perfecting process and the surrendering process and the adverse claim process. Again, remember, we're deemed to be in adverse possession of the property. How are we in adverse possession? Well, because we took it and used it as identification. We weren't supposed to. So technically, we're in adverse possession of someone else's property. And because we haven't settled anything, we are left wide open, or we are vulnerable to attack. And by attack, I mean attachment.
So the CAPS fictional gets put into the trustee in the new trust and put the creator's name as the beneficiary?
Yeah, that's going to be one of our primary focuses. Again, this all depends on what kind of trust you're trying to create. Let's say you're trying to create a charitable trust for the public. Who's going to be the beneficiary of that charitable trust? Is it going to be you, or is it going to be the public? The public should be the beneficiary in that regard. You, as a result of the terms, now technically this would put you back in the trustee spot, right? Yeah, I suppose so. But the trustee side, there may be you having your meek position or your position of dominions being recognized. Now you're a trustee of creator, as meek, as a steward, as a gardener managing this whole place.
So you're the settler and the trustee.
So yeah, it all depends on how and what you're trying to create. Again, you can get pretty creative with some of this stuff.
Is the pledge of the body and its earnings into the Crown Trust considered as a trust deposit or not?
I'd say absolutely, if you describe it to be. It's implied that you're already doing it, but again, it's just the positions of the players are left a little bit open to interpretation. Once we nail those down, the trust doesn't really change other than the fact that, well, we're just playing it different.
Is the birth certificate an estate title to a trust of land, and is it treated as a mortgage?
Yeah, it can be used as a tool for collateral to create a mortgage in equity. Is it, what was the first one?
Is the birth certificate an estate title to a trust of land?
It's an estate title, trust to land. It could stand as a trust receipt if you describe it as such. It won't be. It has the possibility to be, though, if you express it.
So we have a loved one who wants to know how they go about using the registered mail number as the trust. Do you use it as the trust or the case number, or do you just handwrite it at the post office?
Yeah, so take that mailing number, call that your primary trust, your principal trust. I don't want to quite call it a master trust because that term has already kind of lingering in the background. That's one of the realms that the trustees are going to have jurisdiction over now. Our master trust, we have a minor account. Our minor account, once we perfect it and specially deposit our securities, that's what results in the trust. That trust can now be constructed to fulfill a whole bunch of different obligations.
Okay, so you shouldn't use your registered mail number as the case number.
If you're bringing that particular number into your private trust res, yeah, go ahead. We not that long ago, we were sticking that number on everything. In the moment that number appears on any type of property, that is an identifier that someone has expressed a special private equitable trusted interest in that particular property. And unless there's that type of interest attached to that type of property already, guess who wins?
How do you enforce a trust expression?
I would give it to the Attorney General privately and let him do it for you.
Who has succeeded in accessing part or all of their trust?
By name, and this is through secondhand account. That gentleman friend of ours in the United States that's done a fantastic job knocking the ball out of the park I keep referring to. He had a student up here in near Vancouver in British Columbia, Canada, who took a credit card debt. He lost on the public side when he was being foreclosed on publicly. The bank won. The bank was awarded their $2,500 judgment. This guy, and as far as I know, I only knew of him by his first name, which was Phil. So Phil now goes to land titles. He does something at land titles, comes back, goes back into court, and then he walks out with a check for $2.5 million. But apparently he didn't technically walk out with the check. He instructed the judge to keep the funds in private chambers. So, this is a smart move. You're keeping your private trust funds within the judiciary. You're not commingling it with the public. The judges and the courthouses can act as a clearinghouse. They have the ability to exchange money into securities and securities into money, and negotiable instruments into either of those two. And so bills of exchange, it goes on and on and on. Okay, so anyway, the courts are like banks, but even better. So once the bank has a special deposit made into it, all sorts of kinds of cool things can happen in the background.
Okay, so we seem to be getting a lot of questions, Darren, around proof. Now, we answer these questions to the best of our ability, but why do you think the loved ones want so much proof of this?
Yeah, I'm going to say unless you've done a ton of research and read all this stuff and you can actually see it, how this story has unfolded, how this puzzle has materialized through the longer you spent in the rabbit holes, the better equity eyes you have, the better ears you have for equity. All these things start to work and start to turn on. Again, this is all through activation of DNA, because this is something that we're experiencing continuously. This is that charge that you get from doing your due diligence, not slumbering on your rights. In terms of the proofs, why do we always need to see it? Yeah, because when something sounds too good to be true, you instantly need to see proof. That's the bulk of the non-believers. As soon as you read a ton of scripture, you can start to come to an assertion that, hey, there's a lot of promises in this book. Yeah, there's a lot of penalties and lakes of fire in here, but you know what? There's a shit ton of reward. There's a lot of inspiration. There's a lot of good stuff in here. Now, again, we're going to be entitled to that good stuff once we can prove we're clean and we're worthy.
Okay, so when the security agreement is perfected and we no longer possess it and the new trustee is appointed, does the original CQV trust fold in all bonds under the caps and the remainder transferred to new private settler created trust, or is there still a CQV trust in addition to the newly sprung private trust? So how about you just cry on that a little bit for some of our loved ones?
Yeah, okay, so the Sedeke trust, again, there's the implied version is the version where we abandon our interests and there's a trust upon conversion. A conversion happens because when your rights got forfeited, something went and happens. Someone else becomes entitled to that property. Again, this is like squatters' rights. Squatters' rights are this. If you happen to sit your ass down on a certain piece of property for X amount of years, after a while, if the real owner hasn't ejected you or had you removed, after a while you can actually develop a claim to that property. And again, this is through abandonment. It can be considered abandoned or unused or wasted. So believe that or not, even though you did own property at one point, if you don't express enough interest in it, someone can come along and bump you. Because the system doesn't profit. The society doesn't move forward when we are wasting shit all the time. Again, I see hundreds of acres out there of cars, like automobiles, just sitting there, not doing anything. That's such a waste. Why? Because the car manufacturers suggest that it will lower this year model's manufacturer's suggested retail price when you can buy the one from 3 years ago for 75% less, because that's all that they could get for that vehicle now. Well, I don't care. You're not going to take brand new freaking vehicles and just put them out in a vehicle graveyard for them to rot. Like, no, we're not going to live like that no more. That's fucking ridiculous. So again, in order to prevent waste, you grant the public guardian and trustee access to your equitable rights and your equitable estate to go in and manage and do all kinds of administrative things while you're being gone or while you're absent.
Can we declare ourselves a man or a woman to be creditors and issue bonds through the person and then the treasury, or some other way?
Yeah, I'm going to suggest that is something that we're going to deal with a fair bunch here. There's a lot of, we can assume the creditor position, but you know what? I'm going to suggest we secure the creditor so that they can provide a service for us later. They owe us a credit, right? We think of the creditor as we want to be the creditor. Well, okay, how about if we make a special deposit and in credit of that deposit, we are granted the use of property? So really, creditor is going to be something we can bounce around a little bit. I know there's a lot of people out there that want to be the creditor right now. And you know what? In the legal world, I'm sure you can get a lot accomplished with being the creditor. But on the equity side, I'm going to suggest that creator is the creditor. So let's just use what mom and dad left for us, and they happen to be gone for the weekend.
Is the deed of trust our private living trust that we create, or is it for the constructive trust that gets created after the merger of titles and a new trustee has been vested?
Okay, one more time.
Is the deed of trust for our private living trust?
Okay, so yeah, we have to define and describe what type of trust that is. Is it revocable? Is it irrevocable? We need to detail that a little bit. Yes, that is the primary instrument that we create that settles the terms or creates the terms or puts the proper parties in possession or not in possession of certain property interests. This is the new menu that the restaurant is going to be serving.
So our loved one wants to know, is this the constructive trust?
No, this is the resulting trust. We take the result of what we do and evidence of it to a judge and say, hey, Your Honor, we need you to construct the proper trust around the resulting trust that I created.
I'm reading a notary and I find that a notary is a magistrate. So can we use a notary to do an interlocutory order, a vesting order, and an accounting order, then go to a small claims court to get a declaratory judgment from the court to declare it, rather than go before a judge in another court?
Yeah, you can probably do all this by what they call like a summary action. And I'm going to suggest that, yeah, that's probably all going to be possible. If you know how to do it in the right sequence and with the right particulars, yeah, it's definitely doable.
Okay, loved ones, that's what it sounds like to blast through a whole bunch of your questions. So that will tie you over until we get a few more done for you behind the scenes, but you can chew on that for a little bit.